you later. But our next presenter is Mr. Gregory Foreman, who is an attorney, practices law in Charleston. Mr. Foreman graduated from Haverford College in 1984 and graduated in 1991 from the Temple University School of Law. Mr. Foreman is a sole practitioner in Charleston and has lectured and written extensively on issues of family law and child custody. So I turn the program over now to Mr. Foreman. Yes.
The current method we have in South Carolina of litigating relocation cases, I really think needs to be changed in how we go about doing it. And I see the problem with relocation cases is reflected even in our own state's case law. Since 1982, when the McAllister decision came out, the Supreme Court has developed this presumption against relocation, and in the reported cases, the Supreme Court has uniformly rejected these relocations. The Court of Appeals, meanwhile, while noting this presumption, has, since McAllister, uniformly allowed relocations. And if you try to harmonize the law, it's pretty hard to do. And I think a couple of cases that came out in 1999 highlight the sort of problems that the case law is generating. In the case of Rice versus Rice, the Court of Appeals allowed a mother with 3 children who were ages, didn't give exact, but approximately 4, 6, and 8, to relocate to Maine with the children. And the court's reasoning, and it was a very lengthy decision when they're talking about why they allowed the move, but its reasoning appeared to be that the mother could save money by attending cosmology school in Maine, approximately $2,000 over an 18-month period, and that she had family members to provide her daycare and support up in Maine. And that appeared to be the reasons that the court allowed the relocation. What the court opinion did not really analyze, though, is the cost in both money and in the father's relationship with the children that would be imposed by the relocation. To transport these 3 children to a visit in South Carolina, given their age, will require 4 and possibly 5 round-trip airfares from Maine to South Carolina, and a few visits a year, which would be barely enough for anybody to sustain a relationship with the children, would quickly consume whatever savings the mother was going to generate from this relocation. Further, there was no discussion in the Rice case of why the father could not provide some of the daycare that was anticipated that the mother's family would be providing from the relocation, because it looked like the mother would need both daycare on weekends and during the weekdays. The Rice case highlights, I think, the potential injustice that results when the court doesn't fully examine the true costs and benefits of the relocation and allows the relocation to go forward anyway. On the other hand, the case of Pitt versus Olds, I think the court creates a different problem. In that case, the Supreme Court awarded Miss Pitt custody of the child if she remained in South Carolina, but it awarded Mr. Olds, the father, custody of the child if Miss Pitt moved to Arizona. And reading the opinion, one would think that Miss Pitt was proposing moving the child to the West Bank or to Bosnia because of reasoning. If Miss Pitt is a better custodial parent when she resides in South Carolina, how does she become a worse custodial parent merely by moving to Arizona? And the Supreme Court is silent on that issue. And because of that silence, it makes, at least to me, the Pitt decision appear like nothing more than an exercise of raw judicial power, forcing Miss Pitt to remain in South Carolina against her will. This presumption that we have against relocation has created a conflict or tension between the custodial parent's right to travel, which has constitutional dimensions. At some point, an attorney representing a relocating parent is going to review U.S. Supreme Court decisions, and I would start with the Sanez decision, which came out last year, and raise the argument that our presumption against relocation infringes upon the 14th Amendment right to travel. And that argument may well have some merit. The Rice and Pitt cases also illustrate the 2 problems with current relocation jurisprudence. An examination of the case law since McAllister indicates that custodial parents are requesting relocations to meet their own personal needs. If you read the reported case law, every relocation case since McAllister The relocating parent has desired the relocation for one of three broad purposes. One is remarriage. The second is to live closer to their extended family. And the third is educational or job opportunities. And all three of these desires to relocate are legitimate, but none would fall in the traditional best interest of the child framework. That is, they're not being done with the child primarily in mind. However, when a court denies the custodial parent the right to relocate, it interferes with these legitimate interests and may be running afoul of constitutional protections. On the other hand, when the court allows a relocation without first examining the cost that this relocation will impose on the non-custodial parent, it often again leads to unjust results. Perfectly typical example is when a custodial parent, let's say in this example a mother, wants to relocate with a child to Atlanta. How often does the court, when it allows this relocation, reflexively split the transportation responsibilities between the parties? At the same time, the court thinks it's done a service to the non-custodial parent by making the custodial parent responsible for half the transportation. Yet this resolution is unfair. In allowing this mother's relocation, we must assume that the relocation will be beneficial to her. Yet this relocation has costs, and one of these costs being the cost of transporting the child to and from Atlanta. In this example, the court has allowed the mother to obtain all the benefits of the proposed relocation, yet it's imposed at least half of one of the costs on the father. We need to change this paradigm of relocation cases. Relocation cases that are made primarily for the custodial parent's benefit, I think, should be allowed if one of two conditions are met. The first is where the move is not made for vindictive purposes and the non-custodial parent can be made equally or better off by the relocation. And the second is where the move will substantially benefit the child and the cost imposed on the non-custodial parent can be minimized. And what I mean by cost is both relationship costs and monetary costs. To achieve these conditions requires some economic analysis. Basically, when the family court decides a relocation case, what it's really doing is reallocating scarce resources. If we could instantly and inexpensively transport children like something in the world of science fiction, relocation litigation would not be necessary. One scarce resource that the court needs to reallocate is the party's money, which is now needed to transport the child to and from visitations. Another scarce resource is the parents' and the children's time, both time spent traveling to and from the visitations and time that each gets to spend with the child. It is the scarcity and the required reallocation of these resources that makes relocation cases so contentious. A fair allocation of the resources would make relocation cases less contentious and more just, but that requires a better understanding of the costs and benefits of relocation and a systematic approach to their reallocation. An approach that I think works in trying to analyze relocation cases is suggested by an Italian economist of the late 19th, early 20th century named Alfredo Pareto. Pareto analyzed social change in economic terms, and he noticed that sometimes a proposed change in social policy, which might benefit some and hurt others, was not implemented because those harmed by the proposed change would lobby against it. Often the proposed change would be beneficial overall, but still not implemented. What Pareto recognized is that in this situation, if the benefits of the proposed change can be reallocated so that nobody is left worse off, the resistance to the proposed change is eliminated and the proposal has a greater chance of implementation. Such a reallocation, where no one is left worse off, is called a Pareto optimal solution. And if in deciding relocation cases, the court attempted to create a Pareto optimal solution to the proposed relocation, the court would likely allow more relocations while making these reallocations fairer to the non-custodial parent. The first thing the court needs to do is reallocate the time that each parent spends with the child. And hopefully when the court initially sets visitation, it's using an economic analysis of what are termed marginal costs and marginal benefits. For example, when the court initially determines who should have custody, it must then decide how much visitation the other parent should have. For each additional period of visitation with the non-custodial parent has marginal costs and benefits. The benefit of visitation is the ability of the child to sustain and develop a relationship with the non-custodial parent. And each additional period of visitation increases that ability. That increase is called the marginal benefit through each increased visitation period. However, visitation has its cost. At a certain point, each period a child spends with the non-custodial parent may interfere with the custodial parent's discipline. It may be disruptive of the custodial parent-child relationship, or it may prevent the child from engaging in church, school, neighborhood, or extracurricular activities. The extent of these disruptions is called the marginal cost. And ideally, in setting visitation, what the court, I believe, attempts to do is determine the point at which the marginal benefit of an additional period of visitation no longer exceeds the marginal cost of that additional period. Perhaps the standard visitation schedule is nothing more than a rough estimate of where that point is typically achieved. The problem with relocation cases is they impose a transaction cost on the visitation exchange. Each time a child visits the non-custodial parent, the child, and frequently one or both parents, must spend time in transporting the child, and that time is a cost. When the parents live near each other, there's still a cost involved in visitation transportation, but in an era where we think nothing of daily one-hour commutes to work, relatively short drives to exchange the child are not a big concern. But when the child needs to get back from Arizona or Maine to visit with the non-custodial parent, the time costs of transportation become important. There are often cases where the court notices that there will be substantial costs imposed by the relocation, and rather than denying the relocation and thereby interfering with the custodial parent's right to raise his or her children in a supportive environment, the court might be better off allowing the relocation but making the relocating parent solely responsible for these costs. If the benefits outweigh the costs, the custodial parent should still be willing to relocate on these terms. However, if the costs outweigh the benefits, then the proposed relocation was actually nothing more than an unjustified attempt by the custodial parent to gain benefits from the relocation by imposing costs on the non-custodial parent, again without justification. If the relocation is being proposed to benefit the custodial parent, justice requires that the custodial parent be solely responsible for these costs. An ideal way to decide a proposed relocation case is to determine how the marginal costs and benefits of visitation would be affected by the relocation. Where the newly required transportation costs are such that optimal visitation schedule will substantially diminish the non-custodial parent's relationship with the child, there should be substantial and clearly identifiable benefits to the child from the relocation. However, often the relocation can be allowed and the non-custodial parent's relationship preserved by simply allowing the non-custodial parent to have less frequent but lengthier visitation periods. So long as the non-custodial parent is not required to pay the increased cost of visitation transportation, such a relocation can leave both parties and the child better off. To give an example of how this might work, I'd like to discuss the actual case that inspired this presentation. Last year, I was chosen to act as a guardian ad litem in a relocation case. The party's daughter was 2 years old. The parties had lived at that point a few miles away from each other in the Charleston area. They divorced the previous year, with mom having custody and the father having substantial visitation of every other 4-day weekend and overnights in the off week. Mom had remarried and she was offered a home on her family's land in Abbeville. And she informed Dad she was going to relocate and offered him every other weekend visitation. Dad filed for custody, and I was appointed guardian ad litem with 1 week to investigate and make temporary recommendations on the relocation. After meeting with both parents, I quickly determined that the father's extensive visitation had been beneficial to both him and the child, but that there was no good reason to change custody. Rather than trying to determine whether Dad's position, which was basically make Mom stay or give me custody, was better than Mom's position, which was let me move and give him every other weekend, I searched for a resolution that could leave both parents better off. Dad's job required him to travel for days at a time, but 1 week each month he was allowed to work out of his home and could basically work a few hours a day during that week. My recommendation, which the court accepted, was to give Dad a 9-day period each month from Friday until the following Sunday, along with one overnight each month in Abbeville while he was away on business. This allowed him to keep his substantial relationship with his daughter, and both he and his daughter actually benefited from the lengthier stretches of time together. Meanwhile, Mom was now able to move to Abbeville without harming Dad's relationship with the child, thus enabling her to raise their daughter in an environment of her choosing. This solution was Pareto optimal, as it left both parents better off. Had the court merely accepted one parent or the other's proposal, a relocation which benefited the child might have been disallowed, which I think would have done an injustice to the mother, or the father's relationship with the child might have been diminished, which would do him an injustice. Of less importance, but still worth noting in relocation cases, is the monetary costs and benefits of relocation. The transportation costs I've already noted, but there's little analysis in our case law of how extended family or step-parent support may benefit the child. A relocation case that increases the custodial parent's household income by $20,000 but increases transportation costs by $5,000 cries out for a Pareto optimal solution. Simply dividing the transportation costs between the parties is unjust, and in deciding relocation cases, the court should explicitly address all expected monetary costs and benefits in its order, and relocation should be a basis for automatic deviation from the guidelines if that is what is going to be required to make a relocation Pareto optimal. The type of benefits I'm talking about really aren't reflected in the child support guidelines. For example, a stepfather's increased earnings if the parties move to Arizona is not going to be a factor in the child support guidelines. Someone having a mother being able to move to Maine and not have to pay rent because she can live with her own mother is not reflected in the child support guidelines. But if we're going to allow the relocation because these are benefits, we ought to think about deviating from the guidelines if that's going to be what's required to make the relocation fair to the non-custodial parent. Now, in the case I described previously, it wasn't my role as guardian to deal with economic issues. It's easy to develop a just solution to the transportation costs to and from Abbeville. For good reasons, the court felt that this transportation between Charleston and Abbeville should be shared by the parents. And all family court judge would need to do in that situation is determine how much travel time Dad had spent on visitation when both parents lived near each other, how much additional travel time he was going to have transporting the child to and from Abbeville half the time, and then figure out what hourly rate to credit him for, and use that amount as a basis for deviation from the guidelines. Note that in this analysis, we're not very concerned with whether the custodial parent benefits from the relocation, nor do we necessarily need to be. If the custodial parent perceives that a relocation on the terms the court sets forth is not going to be in his or her benefit, they simply will not relocate. After undergoing an analysis of the costs and benefits of a proposed relocation, the court may still find the relocation to be beneficial for the child, even though it cannot be made Pareto optimal. Such cases will typically arise when the relocation can benefit the child's relationship with the custodial parent, but there's not enough resources to preserve the non-custodial parent's relationship with the child at the previous level. This may well have been the situation in the Rice case. Had the Rice decision examined the financial costs being imposed on the father by the relocation and attempted to preserve his relationship with his children, its decision might not have appeared as unjust. Courts have traditionally and will continue to exercise judgment and employ balancing tests in such cases. But until the courts thoroughly examine the costs and benefits in both money and in the effects on the parent-child relationship of these relocations, the court cannot make a just decision on the proposed relocation. In striving to make relocations Pareto optimal, the court will necessarily protect the child's best interests. Any change in the status quo that can leave both parents better off financially and emotionally while preserving the party's relationship with the child will certainly be beneficial for the child too. As I've included in the written materials a more thorough analysis of the issues I'm discussing, I would invite you to review these materials next time you must decide or litigate a relocation case. I'd also suggest you review the Tropia and especially the Burgess decisions which have been included in the materials, because they're very interesting relocation cases from other jurisdictions that are frequently cited. They've been cited by our own Court of Appeals and they're very enlightening on many of the issues discussed today. The current system of deciding relocation cases, I believe, places too great a burden on the custodial parent to justify a proposed relocation, making it harder for the person whom the courts have deemed best able to parent the child to do that job we've given the custodial parent. How much better the Pitt decision might have been if the Supreme Court, rather than merely denying the relocation, had allowed Ms. Pitt to move to Arizona with the children if she was forced to transport the child back to South Carolina a set number of times per year, set up a visitation schedule that could preserve Mr. Olds' relationship with the child, and reallocated the costs of the relocation by deviating from the guidelines in child support. Ms. Pitt may well have decided that the cost of the relocation no longer made the relocation worthwhile, but at least no court would be telling her where she must live. On the other hand, where the court has allowed relocations in the past, it's shown too little regard for the costs being imposed on the non-custodial parent, and it needs to be more aware of those factors in creating a just decision. By approving all non-vindictive relocations that can be made Pareto optimal, and by more fairly allocating the cost of a relocation that is very beneficial for the child, even though it cannot be made Pareto optimal, the court would achieve greater justice for both custodial and non-custodial parents alike. Thank you.